This session is on contracts and financing, and let me tell you why it's important to understand the relationship between the financial world and the contract world. The lender that's going to be making the loan and taking the loan application is going to look directly to the real estate sale and purchase agreement for all of the information necessary to make that loan. That's why it's going to be critical that in drafting a proper contract, that all of the information that we put in there is very detailed so that there won't be any misunderstanding in terms of what type of loan, how long, and etc. Whatever the information is, it has to be there. So let's do a quick review about what contracts are to begin with. A contract is, by definition, a mutual meeting of the minds, and it has to have certain components to it. First of all, the parties need to be competent, and when I say competent, what that means is they need to be at least 18 years or older, and they also need to be mentally competent. In addition, it has to have that offer and acceptance, and let me say this, the offer and acceptance alone is not sufficient. Without a communication back, the contract has not been created yet, so we need an offer, we need an acceptance of that offer, and we need a communication back to all parties so that everybody knows that the contract has been accepted. And that's why we call it a mutual meeting of the minds. Everybody knows what everybody has agreed to. We also need to have consideration. Consideration typically is in the form of an earnest money deposit. It doesn't have to be. But we need to make sure that we spell out whatever that earnest money is, put it in there, whether we collect it at the time that the offer is made or that we collect it at the time of the effective date. You can do it either way. The contract also has to have a legal object. In other words, we can't contract for something that's illegal. It has to be something legally done. Purchasing a home is obviously something that's legal to do. And to follow up on that offer, acceptance, and communication back, in order for us to make sure that this is done properly, the statute of fraud says certain contracts have to be in writing to be enforceable. Therefore, in order for us to have a valid contract that's enforceable, we need to not only have it in writing, we need to have it signed by the parties that are entering into that agreement. And let me say that at this point, that once we have a contract, once we have the actual contract itself, the seller still retains legal title of the property. The buyer will have what we call equitable title. Now, at closing, the seller obviously no longer will have legal title, and that legal title will now revert to the new buyer, who is now the new owner of the property. Also, I would like for you to remember that in certain markets, contracts are assignable. And sometimes people purchase homes and turn around and sell that contract to somebody else. Important to remember, contracts can be assigned provided there's nothing within the text of the contract that's going to prohibit that. Also, that you need to remember that if you do assign a contract, that doesn't necessarily let the person who originally entered into that agreement off the hook. Unless the other person that you've contracted with is willing to give novation, that first party is still going to be liable for that document. Let's get into a little bit deeper details about the contract itself. First, in terms of the dates that we're going to be inserting in there, I think the most important date that we need to be looking at is going to be the effective date. Now, that effective date, everything pivots around that, including the time that the buyer has to get in and make application for the loan. And it also has to do with the time frame that's going to be required for the buyer to actually get the loan approved. So the effective date is going to be very, very critical. We have to make sure that we identify this. Quite frankly, if it were me dealing with the buyers and sellers, I would make sure there's enough emails back and forth confirming what that effective date is. Make sure that I keep a copy in my file so that if anybody wants to know what the effective date is, I can give it to them. Again, the really important dates, there's going to be three. One, the date that the buyer goes and makes application, the date that the loan is approved, and the closing date. Now, with the two contracts that we deal with the FAR bar contract and the CRISP contract. The FAR bar contract is a calendar day contract. The CRISP contract is a business day contract. Therefore, you have to be very cognizant which contract am I dealing with, because these time frames may vary depending on the type of contract that you're dealing with. In addition to the date, you're going to need to know the parties that are going to be involved. You can get the seller's names off public record. Make sure that their names are there in their entirety. And also, if you're representing the seller, make sure that you get the seller to sign on the back of the contract when they approve it, the way that it's titled to them. You want to make sure that the signatures match up. Now, as far as the buyers are concerned, I think that'll be easy enough to get. You'll need to know what their full names are to insert. But one of the questions might be, if it's a husband and wife particularly, besides in the name that you're taking title, you might want to ask, what estate do you want to take the title? As long as we're not giving them advice in terms of how to do this, we're not practicing law, we could at least let them know that there's various ways that they can take title to property. For instance, an estate in severalty would be an individual. That would be a given. A husband and wife is probably going to take title as tenants by the entirety. And the tenant by the entirety simply means that it's an undivided interest, right, and use. It has a built-in right of survivorship. It is exclusively designed for the married couple only in Florida. Other states may have other rules about it, but Florida, this is strictly for the married couple. We also have something called joint tenancies. Now, joint tenancies are typically used for other people that are not in the marriage relationship that want to make sure that there's a right of survivorship. Oftentimes, partners enter into contracts to buy property where if one passes, the other receives it. Brothers and sisters sometimes do that. I think it's important to note that in a joint tenancy, it is equal interest, rights, and use. And in order to establish it as a joint tenant, you have to have very specific language in the contract that says that there is a right of survivorship. If one passes, the other or others will absorb their interest. As far as the earnest money deposit is concerned, we've already talked about that a little bit. Remember that earnest money is not a requirement of law. It just shows, in some cases, good faith in the negotiation process, but it's also going to act as liquidated damages in the event that the buyer breaches. So we have that earnest money that's going to be there just in case the buyer breaches. The legal description is also going to have to be in there, and remember that legal description has to be full and complete. I've outlined a number of the types of legal descriptions that we have, and I want you to become very familiar with those. The first one is the metes and bounds. The metes and bounds is, honestly, it is the most accurate and the most complex legal description that we have. It's the only one that has a point of beginning. So that from a legal standpoint, it's going to be probably the largest in terms of volume of legal description. The next type of legal description is going to be a platted subdivision. The platted subdivision is where we're simply taking an area and we're dividing it up into subdivisions. Some people call it a subdivision plat map. And let me share with you the significant difference between the two of these. In the metes and bounds legal description that we're going to be dealing with, what we're going to be saying is that we need to have the section, township, and range identified. It has to be there. We have to have the county it's located in. But as far as a plat method, since this is recorded on public record, we need to know the county, the plat book, and the page that it's located. Now, if you're dealing with a condominium works pretty much the same as a plat book. You need to have the page, you need to have the county that it's located, the condominium, the unit, and you'll also need the book and page number that it's recorded on public record. You'll need to have the purchase price inserted. you'll need to have the financing terms all spelled out. And that's what I want to get into right now, are the various financing terms, because there's a lot that goes on here that you need to make sure that we understand. There are a number of your paragraphs that are going to be in here that can create problems. And let me say this, in most cases, your contracts are going to be contingent on a buyer obtaining their financing in a certain amount of time. The FAR contract, the way it reads, is that a buyer has to notify the seller no later than the date that you have inserted for the date that the loan approval is supposed to be made in writing that the loan has been approved. Failure to do so in a timely manner, either party can withdraw, walk away. Now, as far as the CRISP contract, the way that it reads is that the buyer has to notify the seller in writing on the date that you have inserted for the loan approval, or 10 business days prior to closing. So we have some default dates here that we have to be very aware of, that if we breach these dates, that all of a sudden this contract becomes voidable and either party can withdraw. And I think that the thing to note on either one of these is that if they intend to move forward to closing and don't give notice to each other of their intent within the designated amount of time in the contracts, it is presumed that the financing contingency has been removed, and therefore they're moving to closing. At some point prior to closing, if the buyer can't get their financing because of whatever reason, they've waived the financing contingency. Therefore, if they want to breach, they're going to lose their deposit. We also have to discuss in all of our contracts chattel or personal property. Make sure that it's spelled out. As far as title inspection, there's going to be title work done on the property. Buyers always have the right to review their title binder prior to closing, typically 5 days prior to closing. The CRISP contract allows it up to the day of closing, but they do have the right to evaluate their title and how good the title is. Spelled out in there is going to be the place, date, and time of the closing. And let me make a comment about time is of the essence. In all of this dialogue that we've been talking about, every time that you see a date that has to be met, in contract law, this means that time is of the essence. And what that means is that these dates must be strictly enforced. That if you breach or go past the dates that you've specified, that contract might very well become either void, but certainly will become voidable by either party if they chose. They'll be talking about prorations of certain items. They'll talk about surveys, inspections. So there are a lot of things that this contract has got to talk about. Let's talk about a breach of contract in a little bit more detail though. I've already mentioned that if the buyer breaches, the seller can retain the earnest money deposit as liquidated damages. However, if the seller chose, they could sue for specific performance. Now, a seller can't have both. You pick one. And that's why we typically like to get a big deposit so that the buyer does breach. That resolves the issue for the seller. They don't have to worry about suing for performance or unliquidated damages. Now, if the seller breaches, the deposit is a non-issue. It's the buyer's deposit already. So the buyer could sue for specific performance. They could sue for unliquidated damages, and those are damages that could occur in a lawsuit that may be ascertained at a later date. So there's other things, other methods of being able to sue for. There's going to have to be a signature by all the parties. Make sure that they're signed and dated. And once again, let me make a comment about the effective date. The effective date is extremely critical. By definition in contract, the effective date is the last date that the last person has signed and or initialed, and all parties have received a copy of the contract. That goes back to what we talked about earlier. What's the definition of a contract? It is a mutual meeting of the minds. There's an offer, there's an acceptance of that offer, And then there is a communication back to make sure that everybody knows what everybody has agreed to. And on that, I think I'd like to review with you the important information in this particular chapter. Just remember that a meets and bounds, and also as far as the plat method, when we're talking about these various kinds of methods of legally describing property, the physical address of the home is not a requirement of contract. The physical address is nice to know. It's nice to know where to pull the truck to deliver the furniture, but it is not an important issue with the transfer of title. There must be a legal description involved in order to transfer title. Remember what time is of the essence is. Time is of the essence simply means that time must be strictly enforced, that if you breach a time, that contract may become voidable. The seller, up until the day of closing, remember, will always have legal title to the property. The buyer will have what we call equitable title. In other words, they have an interest to the property, but they won't have legal title until the closing occurs. As far as the ownerships to real property, we talked about the various types, the tenancies. Remember, tenant by the entirety is a husband and wife that has a built-in right of survivorship, is undivided interest, rights, and use. We said the joint tenant was equal interest, rights, and use, but had to be a very specified right of survivorship. It's not for husbands and wives. And then we have a tenant in common. Now, let me tell you why tenant in common is so important. If you have a husband and wife that may have a marriage from before and have kids from another relationship, and they'd like to leave them an interest in real property, if they use a tenant by the entirety or a joint tenant, that has a right of survivorship and they cannot will property away. The only way that you can will property away is through a tenancy in common. And that's all we have for the review for this particular chapter.